Chris, can you go straight through the noon since we're getting all started? Two seconds. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey. People represented by Ms. Clark, Mr. Darden, and Mr. Gordon. The jury is not present. Mr. Cochran, you had a comment to make?
Yes, Your Honor. I have three quick matters, if I might. Yesterday, at the end of the day, when we were leaving, Your Honor, I was advised that when Mr. Ron Shipp left the witness stand, finally, he walked through the gates there, and he made what has been called a power sign toward the Brown family. This was seen by people in the back row, and the jury was apparently still here. And given that eventuality and the fact that we're told by independent people that that took place, the court needs again perhaps to inquire or check with your staff or check with the photographers in the back row. And I think you can verify that. Those kind of over displays by this witness, I think, have no place. And again, I think it would require an admonishment of the jury because it's just thoroughly improper. That's item number one. The second item has to do with a discovery issue. I had a conversation with a man named Scott Kennedy, Your Honor, on Wednesday evening. Mr. Kennedy is a man who says that, who took a video of the ending of the recital on June 12, 1994. A video that includes Mr. O.J. Simpson with one of his children, his greeting the Brown family, has the Brown family on it. And apparently the indication is that none of these parties knew they were being videoed. The concern that I have regarding Mr. Scott Kennedy is that he indicated to me, he sent this video to Ms. Marsha Clark, he said specifically last summer. And in our, at least my review of the discovery, we have never, ever received that. This video has now been shown, and we expect, of course, to have our copy shortly. But if the prosecution had that, we were entitled to that some time ago. And Mr. Kennedy said that he did, in fact, send it specifically to Ms. Marsha Clark, and there was no follow-up on it. The third thing has to do with a witness by the name of Leif Tilden, Leiftilden. So Mr. Leif Tilden is a witness that has been, in fact, interviewed by the prosecution. He's a witness who says that he saw four men in the area of the Bundy Street address near Dorothy on the night of June 12, 1994, as I understand it, four Caucasian men, or not African-American men, between the time of 10 and 10:30. He also indicated he has, in fact, been interviewed by the prosecution. We received no information about this man at all, no reports or whatever. As the court has pointed out to me, discovery is reciprocal. These are, I stand here understanding that, and I want to bring this to the court's attention for each, the last two matters, and also the Shipp matter. I'd like the court to conduct some investigation because we should not be prejudiced because a witness like Shipp is overzealous. On these other two things, we would like to have an understanding if the prosecution has the Kennedy tape, and we'd like to have the reports, if they're available, on Mr. Leif Tilden. We think he will be a very important witness, especially in view of the fact that the prosecution knew that they had another witness who talked about four men and around that area at between 10 and 10:30 on June 12th. Certainly it would be misleading to the jury to talk to have Ms. Clark's opening statement, the reopening statement, on Monday. So I want to put those things on the record, if I might, Your Honor.
Mr. Darden? Good morning.
It's correct that members of the DA's office have interviewed the gentleman Mr. Cochran just referred to. We did that roughly 24 hours ago. Just this morning before coming down here, I signed off approving the release of the tape of that interview to Mr. Cochran. And so we're aware of that person. We're aware of our duties under the rules of discovery, and we are complying, and they will be receiving written notification moment. And I should indicate as well that this isn't someone that we've known about for several weeks or several months. He came forward after he heard Mr. Cochran's opening statement and his reference to Ms. Gerchis. And I believe he'll testify that he saw 4 young men in the area that night, but that they appeared to be college students. None of them wore knit caps. In fact, not all of them wore caps at all. And the caps that were worn were baseball caps. And so I don't know how relevant his testimony will be if he's called as a witness, but we will certainly provide counsel with that discovery.
All right. That appears to be within the court's order, which was to give notice within 1 business day, unless there's some other reason. Okay. How about the Scott Kennedy video?
I'm not aware of that video, and Mr. Fairtlow is here, and he handles most of the discovery. If we have such a video, we will turn it over. I don't think we do, but someone upstairs, I'm sure, is checking right now, and if we have it, we will give it to Mr.
All right.
Carter.
I'd like to know when we come back at 1:30, and if you recall, I've asked both sides to submit to the court an inventory by today, and the record should reflect I have received the defense inventory this morning from Mr. Douglas, and I will, so that I'll know what everybody has from this point on.
Okay, your senior DA investigator, Mike Armstrong, is working on that right now. It'll be here by 3 o'clock.
All right. All right, and as to the gestures by Mr. Shipp, any comment by that?
I saw no such gesture, but I don't think any such gesture by Mr. Shipp is any more inappropriate than what happened here yesterday. I believe it was yesterday when the court was introduced to Mr. Douglas's wife, Mrs. Douglas, and after that introduction, and I have no problem with that, she walked over to the defendant, she shook his hand, she conversed with him, right here in front of the jury. Right here in front of the jury. I thought that was highly inappropriate, but I didn't bring it to the court's attention. I don't see any need to get or to complain about every little thing that happens in the courtroom, but I didn't see it, and so I can't address. Yeah. In addition, when Detective Farrell left the witness stand the other day, as he passed by, the defendant said to him, "Thanks for telling the truth," or words to that effect, within earshot of the jury. Okay, so if Mr. Shipp perhaps violated the court's rule in some minor way, he is not the only one, and I don't think the court should draw attention, the jury's attention to whatever occurred yesterday. And Mr. Cochran didn't see it. We don't know that it happened. Maybe it did. Maybe it did.
So I think I'm going to have to become Argus. I have to stay here the whole time.
Well,
I'll need instant replay.
Yeah, hopefully that won't be necessary, Your Honor. I think most witnesses, I think, will comply, conduct themselves appropriately. We don't have this problem every day. But this particular witness has shown a proclivity or propensity for doing this. You'd already warned him several times, and you'd already cautioned the jurors regarding him. And then what I'm asking the court to do, since I was advised of this, is to query people who actually saw it, because it would be a flagrant violation. That's far different than Miss Linda Jackson Douglas, who did not shake Mr. Simpson's hands at all, being introduced at a time in an appropriate manner. That's far different. The people always seem to confuse, Your Honor, that whenever there's something that happens, they want to throw something and say, well, so-and-so did that. That's not the question. As Ms. Clark herself said at one point, 2 wrongs, even if there was a wrong, wouldn't make a right. We have to deal with the conduct. The last thing I want to say, and I appreciate Mr. Darden being forthcoming about the tape, they didn't tell me about it. I'm the one who brought it up, and I'm glad we're going to get that. But that videotape was from last summer. This man took the videotape and got it in July. So was your response, we should know something by the end of the day on that?
Yeah.
All right.
Yep.
Okay. You said
All right.
like it was in July.
Thank you, counsel.
Thank you.
All right, Deputy McNair, let's have the jurors, please. Ladies and gentlemen, it was brought to my attention that yesterday afternoon when Mr. Shipp was leaving the courtroom, he may have made a gesture to somebody in the audience that you may have observed. You were to disregard any conduct like that here in the courtroom. All right, Mr. Darden, would you call your next witness?
Thank you, Your Honor. Good morning, ladies and gentlemen. Your Honor, the people would like to call Sergeant Lerner to the stand.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the class and opinion before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please be seated and state and spell your first and last names for the record.
My name is Robert Lerner, R-O-B-E-R-T, L-E-R-N-E-R.
Thank you.
Mr. Darden.
Thank you, Your Honor. Good morning, sir.
Morning.
Sir, on October 25, 1993, were you a police officer?
Yes, sir.
Were you a member of the LAPD?
That's correct.
And on that date, around 10 p.m., did you respond to a 911 call for help?
Not for help, but I did respond to a 911 call.
And did you respond to 325 South Gretna Green,
Yes, sir.
the home of Nicole Brown?
Yes.
Why did you go to that location?
The 911 call stated there was a domestic dispute. It was marked code 2 high, which is in an urgent call.
Were you in uniform?
Yes, sir.
Were you in a black and white police vehicle?
Yes, I was working a two-man basic car in West Los Angeles area with my partner, Spencer Marks.
Okay. And did you and Officer Marks proceed immediately to that location?
Yes, we did.
And when you arrived at 325 South Gretna Green, Nicole Brown's home, did you see a vehicle?
Yes.
What kind of vehicle?
It was a Ford Bronco, white in color.
And where was that Ford Bronco when you arrived at Nicole Brown's home?
The vehicle was parked southbound in the street in front of the location.
Was the vehicle parked at the curb?
No, it wasn't.
How far from the curb, if you recall, was it parked?
Approximate between 4 and 6 feet.
Okay. Or was it parked or was it stopped in the street?
Apparently it was stopped in the street. The ignition was off, but the headlights were on.
Did you see anyone inside the Bronco at that time?
No, sir.
Is there a driveway in front of the residence at 325 South Gretna Green?
I don't recall.
Okay, but the vehicle was in the street.
Yes, sir.
I take it you got out of your police vehicle?
Yes.
And did you meet someone at that time?
Yes, sir. In front of the location, 325 South Gretna Green, we met Nicole Brown.
And could you describe for us the Nicole Brown's demeanor?
Well, she was visibly shaken. She was upset. She was concerned, and she was scared.
Did you notice any signs of any physical injuries on
No.
her face or on her neck at that time?
No, sir.
Did you have a discussion with her?
Yes.
Now, when you met Nicole Brown in front of the house, was there anyone else with her?
No.
What did you do after you first saw Nicole Brown?
We wanted to make a determination if the individual mentioned in the comments of the call as the individual to whom we were responding was still at the location. She said yes, he was, that his name was O.J. Simpson. He was in the
Sustained.
I'll ask another question, Your Honor. After you spoke to Nicole Brown, what did you do?
we made a follow-up to the rear house, the guest house.
Did you have to walk from the front of the house to the back?
Yes, sir.
Did you go through the house, or did you walk around to the side of the house?
We walked through the house.
Okay. And did you exit into the rear yard of the house?
Yes.
Now, is there a rear door to the house?
There is. It's a double French door.
And did you take a look at that door as you passed through it?
Yes, sir.
And what, if anything, did you notice about the condition of that door?
The door had been split near the top and bottom of the door. of the door that has the two deadbolts that go into the floor and into the ceiling.
And did you see someone at the rear of the house that night? Someone that you now see here in court today?
Yes, sir.
Point to that person.
The defendant, Mr. Simpson.
Indicating Mr. Simpson.
You saw the defendant in the rear or at the rear of Nicole Brown's house that night?
Yes.
Did you speak to him?
Yes.
Did he speak to you?
Yes, he did.
Was there someone else present at that time?
Yes, there was.
Who else was present?
An individual I learned later was Cato Kalin.
Cato Kalin was present.
Yes, sir.
Describe for us, if you will, the defendant's demeanor when you saw him in the rear yard.
The defendant was agitated. He was upset, pacing back and forth, and he was speaking loudly to Mr. Kalin.
Can I have one moment, Your Honor?
Yes.
Thank you. I have nothing further for this witness.
All right, Mr. Cochran.
Thank you very kindly, Your Honor.
Good morning, Sergeant Warren. Lerner.
Good morning.
Sir, as I understand it, you responded to this 911 call on October 25th, 1993. And what time of evening was that?
It was around 10 o'clock.
And you referred to we in the course of your testimony. Who were you accompanied by at that time, if anyone?
My partner, Officer Spencer Marks.
And the two of you were in a two-person car, is that correct?
That's correct.
All right. And when you got to the location at around 10 o'clock on October 25th, 1993, were all parties outside the Gretna Green residence?
Nicole was in front of the residence. The other two persons present were in the rear of the residence.
All right.
So, in fact, all parties were outside the
All right.
residence.
They were outside at different locations,
That's
as I
correct.
understand your testimony.
Yes.
Then as you got out, you'd pull up in the front of the residence, is that correct?
Yes, sir.
And you first encountered Ms. Nicole Brown Simpson, and you had a brief conversation with her at that time, is that correct?
That's correct.
You had occasion to observe her, and it's true, is it not, that she had sustained no physical injury that you could see, is that correct?
That's true.
And in the course of your conversation with her, without telling us about that conversation, you ascertained that she had not been struck or hit at any time, is that correct?
That's correct.
Now, how long would you say that you spoke with her before you went to talk to Mr. Simpson and Mr. Kalin, sir?
It was a brief conversation, maybe a couple of minutes.
All right. And at the time that you were talking to Ms. Nicole Brown Simpson, was your partner, Officer Marks, there also at that time?
Yes, sir.
All right. And after you spoke with her, as I understand the sequence of events, you then went around to this rear house, is that right?
We went through the interior of the front house to the rear house.
Okay. And when you got there, was Mr. Simpson and Mr. Kalin outside of the rear house?
No, sir, they were inside.
All right. Did you go inside or did you have them come outside?
I went inside.
All right. And were you still accompanied by Officer Marks?
Yes, sir.
All right. So was you and Officer Marks inside the rear house speaking with Mr. Cato Kalin and Mr. O.J. Simpson, is that correct?
That is correct.
At that time you had a conversation with Mr. Simpson, did you?
Yes, sir.
And in that conversation, Mr. Simpson told you...
Objection, Your Honor. Objection.
I'd like to finish the question.
Finish the question.
In that conversation, Mr. Simpson told you about the subject matter of the argument. And you can ask that yes or no, can't you? Yes, you can ask that yes or no.
You can answer the question, yes or no.
Yes.
And was Cato Kalin present when you had this conversation with O.J. Simpson?
Yes.
And the entire conversation wherein you were talking, you and I presume your partner, Mr. Marks, were talking to Mr. O.J. Simpson, how long did that conversation last?
Several minutes.
Now, at some point, Sergeant Lerner, you or your partner had occasion to record the conversation with Mr. O.J. Simpson?
No.
You did not do that?
No.
Is there another officer named Lally, L-A-L-L-Y,
There's a sergeant named Craig Lally, yes.
and he was a sergeant at that time in West Los Angeles?
Yes, he works West Los Angeles.
Did he respond to that scene at some time that night?
Yes,
And while you were still there?
correct.
And while you were there, did you see him with a tape recorder taping statements from Nicole Brown Simpson and O.J. Simpson regarding the events that had taken place that evening?
No,
Are you aware, as you sit here today, that there is a tape recording of the individuals from that particular night?
Objection.
I'm asking if he's aware.
You can ask the question.
yes,
And is there such a tape recording?
yes,
And you've heard that tape recording?
yes.
All right, now let's talk about that. We won't go into the tape recording right now, but
Before we do that, how many questions?
Yes, with the court order. All right, thank you, counsel. Mr. Cochran?
may I proceed, Your Honor?
Please.
Sergeant Lerner, did you, when you listened to the tape, is there more than one tape?
Not to my knowledge.
You heard one tape when you listened to it, is that correct?
That's correct.
When was that you last listened to the tape?
It was yesterday, I believe,
And where'd you listen to it?
in the district attorney's office.
And they were present?
Yes, Mr. Darden was present.
Darden played it for you?
Yes,
That was what time yesterday?
yesterday morning.
Before court started?
Yes,
And when you listened to that tape, you could hear the voices of the parties, could you?
yes,
And you recognize those voices?
yes,
And did you hear Mr. Simpson's voice on the tape?
yes, I did.
And who was conducting the interview of Mr. Simpson on the tape that you heard?
I was myself and Sergeant Lally.
So you were present when the interview was actually taking place?
Yes, I was.
And with regard, did you hear the voice of Miss Nicole Brown Simpson on the tape?
Yes, I did.
And did you hear any officers' voices on that?
Yes,
And who was present?
I was present. Sergeant Lally was present.
Did you know these conversations were being taped?
No, I did.
In other words, Sergeant Lally was taping and didn't tell you either?
That's correct.
So it was surreptitiously taped.
Yes.
So we're clear about surreptitiously, so you and I know what we're talking about.
Well, I'm not sure if Mr. Simpson knew he was being taped or not. I did not know. So with regard to me, it was being surreptitiously taped
Taped by your brother officer.
by my supervisor.
Okay. And at what point did you find out that the conversation had been surreptitiously taped?
Yesterday.
You didn't know that until yesterday?
Had no idea.
From October 25th, 93.
That is correct, sir.
Now, if you didn't know, you think Mr. Simpson knew?
Sustained.
Yeah, he's right about that, Your Honor, probably. But, I mean, let me ask you another way, Your Honor. Nobody came up to Mr. Simpson and said, we're going to tape you surreptitiously with the tape. You didn't hear him say that, did you?
I don't believe if somebody said we were going to tape him surreptitiously, then it would be a surreptitious
That's
tape.
an oxymoron, isn't it?
I believe it is.
Right. So that's the point of the question. So that you heard nobody say that, did you?
No, I didn't hear anybody indicate to Mr. Simpson that he would be surreptitiously taped.
And you didn't hear anybody say to Miss Nicole Brown Simpson, you're going to be surreptitiously taped either, did you?
No, I didn't.
Now, this tape that you listened to yesterday morning in Mr. Chris Darden's office, how long was that tape altogether?
It was approximately 30 minutes.
That includes both of the parties, is that correct?
Yes, sir.
And it includes your questions and answers.
Yes, it does.
So that I can put this in perspective for the jury, you described for us how you met with Nicole Brown Simpson out front, went through the house, right?
Correct?
Then met with Messrs. Simpson and Cato Kalin in the back house.
Correct.
Was Sergeant Lally your supervisor there at that time?
No, there was approximately 10 minutes difference from our time of arrival to Sergeant Lally's arrival.
So by the time he arrived, let's assume it was about 10 minutes after you arrived there, right?
Okay.
At that point, where were you?
Near the rear house, or in the rear house.
Were you still talking to Mr. Simpson and Mr. Kalin?
Yes.
All right. Did he come back to where you were?
Yes, he did.
And in the order of this tape, there was this surreptitious tape. Who's on the tape first, Mr. Simpson or Mr.
Counsel, I think we're going into the content of the tape at this point, aren't we?
Your Honor, I was
You're asking him to interpret the tape, and at this point, it's hearsay.
because he was present. But, all right, Your Honor, I'll move on. I presume Lally will be here at some point. In the order of events, however, did Sergeant Lally come to the rear house and ask some questions first?
Sergeant Lally approached the rear house. I, at that time, approached Sergeant Lally.
Okay. And then after you approached Sergeant Lally, did you talk to him?
Yes.
And after that, where did Sergeant Lally go?
Stayed with me.
And, okay, the two of you stayed together, and then where did you go?
There were others present.
Okay. Who else was present?
Mr. Simpson was present.
Okay. Mr. Kalin was present also?
He was in the immediate vicinity.
Okay. And did then you hear Sergeant Lally start to talk to Mr. Simpson at that point?
Yes.
And did you complete a conversation with Mr. Simpson before you went some other place?
Yes.
And when you completed the conversation with Mr. Simpson, how much time had passed?
10 minutes, 10 minutes.
And when you completed this 5 or 10 minutes of conversation in which you spoke and also Sergeant Lally spoke, right?
Yes.
Where
And
did-
also, Mr. Simpson spoke.
And Simpson. All right, yes. Where did you next go at that point, if you recall?
I went back into the interior of the house, the main house.
And did you at that point meet and talk with or have a conversation with Mr. Nicole Brown Simpson?
Yes, I did.
And who was present during that conversation?
Sergeant Lally was present, and Nicole Brown Simpson was present.
And did you hear them again engage in conversation
Yes, there was a brief engagement.
along with yourself?
Yes.
Now, you described for us that there had been some damage done to some rear double French doors.
Correct.
Is that correct?
Yes, sir.
And was the subject matter of those doors, did that become part of the conversation that was conducted that evening by you? You can answer that yes or no.
Sustained.
Did you determine or ascertain that these double French doors had been partially broken before anything occurred that evening? Did you find that out?
Sustained.
I'll link it up.
Sustained.
Did you take any pictures of those doors that night?
No.
Did Mr. Simpson make a statement about, it's a subject matter statement, may I complete it?
It's hearsay, though. It's telling us what the content was.
Very well. After you completed the conversation with Mr. Nicole Brown Simpson, where you were present and Sergeant Lally was present, where did you next go that day, if anything, that evening?
We returned back to Mr. Simpson's location, which was near the guest house in the rear.
And did you have a further conversation with him?
Yes, sir.
And that was again you and Sergeant Lally? Is
Yes,
that
sir.
right?
Correct.
And how long did that conversation, this second or third conversation with Simpson take?
Another probably 5 to 10 minutes.
Now, you had indicated that at some point when you first saw Mr. Simpson, he appeared to you to be upset and agitated. As you talked to him and he talked about the events of that night, did his demeanor change, become less agitated?
Yeah, I would say it did.
And would you say that's reflected in the way he responded to your questions during the various conversations?
I'm sorry, I don't understand the question.
Yes. With regard to the change in his demeanor from being agitated to being more calm, would you say that was reflected in the way the two of you talked during these various conversations you had with him?
I would say I had a calming effect on Mr. Simpson, yes.
Right. So that by the time you concluded your conversations, you and Sergeant Lally, he was in a calmer state than he had been in earlier, is that right?
There was a point during the conversation where he again became agitated.
All right. And then you had a calming effect?
Yes.
And then he became calm at some point again, is that
Yes,
right?
that's correct.
And there were no arrests made that night, is that correct?
That is correct.
And with regard to this entire incident, if we assume that you arrived somewhere around 10 o'clock p.m., Sergeant Lerner, what time did you finally leave the scene that particular night?
On our computer screen, when we leave the scene, I put us on a follow-up,
Yes.
and it was approximately 23:28. That would be 11:28.
All right, so you were out there about an hour and a half altogether?
Pretty close.
And with the exception of maybe the first 10 minutes, it was you, your supervisor at that time, Sergeant Lally, and your partner at that time, Spencer Marks.
That's correct.
Right. Did you also talk to Cato Kaline?
Not really.
When you listened to this tape, this audio tape in Mr. Chris Darden's office yesterday morning, did you ever hear Chris Darden strike that? Did you ever hear Cato Kaline's voice?
No, I didn't.
Hope you didn't hear Chris Darden's voice, no.
No.
Very well, I have nothing further of this witness at this point, Your Honor.
All right, Mr. Darden?
Thank you, Your Honor. Sergeant Lerner, you were at Nicole Brown's house for an hour and a half?
Executive form of counsel's theatrics, Your Honor.
Overruled.
Thank you, Your Honor.
Yeah.
Sustained.
I didn't know that. You were there an hour and a half?
We arrived at 7 minutes after 10. We departed at 28 minutes after 11.
Did you have other calls that you had to respond to or were supposed to respond to during that time?
We were on a high priority call. This particular call was considered a high priority call, and so we were off the air.
So you had no other responsibilities or duties during that 1.5 hour period, that is, except to deal with the situation involving this defendant and Nicole Brown?
That is correct.
Did you stay at the location any longer than you felt necessary?
No, sir.
So you felt that you needed to be there an hour and a half?
Correct.
Why?
We had a duty to ensure that our investigation was complete, that there was no possibility or limited possibility of any further incident that evening, and we were required to complete a crime report at the location.
You indicated, or rather you told my good friend Mr. Cochran that the defendant was upset when you first met him.
Yes, I did.
And you say that he then became calm. Is that right?
He calmed.
And I believe you told Mr. Cochran that you had a calming effect on him. Is that right?
That's correct.
Nicole Brown didn't have a calming effect on him.
Objective form of that question. Cost of speculation, objective form of that question.
Sustained.
Were you the only person that had a calming effect on the defendant?
Objective form of that question.
Overruled.
People there.
Overruled. You can answer that question.
Thank you, Your Honor. Yes, I believe my partner also had a calming effect, as well as Sergeant Lally.
Well, both you and your partner are police officers, correct?
Yes, sir.
And you were in uniform.
Yes, sir.
Is that what calmed the fact that you were a police officer?
No.
Sustained. The answer is stricken.
But he was upset when you first saw him, and then at some point...
Ask and answer, Your Honor.
Overruled.
Then at some point he became calm, correct?
He did become calm, not directly because of the uniform.
What calmed him?
I imagine,
Speculation, Your Honor.
Sustained.
Did you make an effort to calm the defendant?
yes, I did.
But he became angry and upset again, is that correct?
Yes, he did.
And did you calm him again?
Attempted to.
Were you able to?
I thought I was fairly successful in that the incident did not escalate after my arrival.
Well, what do you mean when you say that the incident did not escalate?
Up until the time of my arrival, there had been no physical contact between Mr. Simpson and Nicole Brown. And the entire period that my partner and myself and Sergeant Lally were present, it didn't escalate into a physical confrontation between the two parties.
How many officers arrived at Nicole Brown's house that evening?
I believe there were a total of 5.
And did all 5 of those officers remain at that house for 1.5 hours?
For the most part of it, yes. There were 2 officers arrived after my arrival and departed about the same time,
You were working the PM shift?
mid-PMs.
How many patrol officers routinely work the PM shift?
Overruled.
Mid-PMs has 1 basic car and usually an X car, usually 4 officers.
So all the officers on the shift, or rather all the patrol officers on the shift were at Nicole Brown's house for an hour and a half?
There was 1 mid-PM watch unit, which is myself, and 1 unit from the early PM watch, which normal end of watch hours is 11:30.
So half the watch then was at Nicole Brown's house, Sergeant Lerner?
Yes, sir.
You're right. I object. It's
Over.
redundant. It's cumulative.
Overruled.
And about the tape you just mentioned, you didn't tape the conversations, is that correct?
No, I didn't take the
You
conversation.
don't have the tape, do you?
No, I don't.
You didn't know the conversations were even being taped?
Had no idea.
You're not really the person to ask about that tape, were you?
I just want, you can't ask him that. I object.
That's argumentative. That's argumentative.
I'm
Sustained.
sorry, I apologize, Your Honor.
Right.
I apologize, counsel. I have nothing further.
All right.
Just a couple of questions, Your Honor.
Couple.
A few more questions, Sergeant Lerner. As I understand it, there were no criminal charges filed regarding this incident, right?
That's incorrect.
There were criminal charges filed?
Yes. Well, I don't know if they were filed. I completed a crime report regarding trespass and
But
vandalism.
you never had to go to court on this case, right?
I never went to court on
All
it.
right. You never had to testify or anything?
No,
right?
sir.
As far as you know, Mr. Simpson never went to court on this case, right?
As far as I know.
All right. Now, with regard to that, this time you spent there, when you, Mr. Simpson, had left the scene before you actually left, right?
That's correct.
All right. And you and your partner stayed there for a period after that, is that right?
Yes, sir.
And you were talking about escalation. After you left, maybe around 11:30 that evening, you received no further calls or did not have to respond to the Gretna Green residents that evening, is that correct?
That is correct.
And you had done your job with
I
regard
felt
to
so.
ameliorating the situation and making it better, is that right?
Apparently so.
All right. Thank you very kindly, sir.
Couple of questions, Your Honor. You say you completed a vandalism and trespass report?
Yes.
Is there a special box that you check on a crime report in situations like these?
Yes.
What does that box say?
That's a domestic violence involved box.
Domestic violence?
That's correct.
You checked that box?
Yes, I did.
On the crime report?
Yes, sir.
Thank you.
Anything on that?
Nothing on that, Your Honor. You may be excused.
All right. Sergeant, I'm going to excuse you from further attendance today. Please don't discuss your testimony with anybody else until the trial is completed, except with the lawyers on the case. Thank you very much for coming in.
Thank you, Your Honor.
Mr. Darden?
One moment to check and see if the next witness.
Please. Madam Reporter, how's your paper supply? stand over here behind the court reporter, please, and face the clerk.
Right over here now.
Right there. Stand right there. Raise your right hand.
You do solemnly swear that the testimony you may give in the cause now hearing before this court should be the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. Please have a seat in the witness stand and state and spell your first and last names for the record.
My name is Catherine Bowe, C-A-T-H-E-R-I-N-E, Bowe, B-O-E.
Thank you.
Mr. Darden.
Thank you, Your Honor. Good morning.
Good morning.
Without giving us your specific address, can you tell us, or rather give us the intersection in which you live?
I live at the intersection of Shetland Lane and
During 1992 and 1993, did you live next door to Nicole Brown?
Yes, I did.
Her home on Gretna Green was directly adjacent to your home?
Yes, it was.
Okay. And you lived at your home with Carl Colby, is that right?
Yes, my husband.
Let me direct your attention to April of 1992. First of all, during April of 1992, did you know Nicole Brown?
Yes, I did know Nicole.
Okay. And did you consider her a friend?
Yes, I certainly did.
Did you know her husband at the time?
I did know her husband.
I'm sorry?
I did know her husband.
Okay. The defendant seated here in court? You knew him?
Yes.
Directing your attention to the last week of April 1992, at about 11:30 p.m. Did you see the defendant at that time?
Yes, I did.
Okay. And where were you when you saw the defendant?
I was in my upstairs bedroom.
Okay. And where was the defendant when you saw him?
He was on the sidewalk below.
And what did you see the defendant do?
I saw him walking around on the sidewalk, walking from Shetland up Gretna Green, slowly.
Did he only walk from Shetland to Gretna Green one time?
I felt uncomfortable watching him, so I didn't.
Non-responsive. Ms. Bowe, if you would, listen carefully to the question that the attorney asks you and try to answer only the precise question that is
All
asked
right.
of you. Mr. Darden?
Thank you. Okay. How many times did you see the defendant walk from Shetland to Nicole Brown's house on Gretna Green?
On that night, I saw him walk once.
Okay. Did you ever see him walk back, that is, from Nicole Brown's house to the corner at Gretna Green?
No, I did not.
What did you do the first time you noticed the defendant outside on the sidewalk? Well, strike that. Let me withdraw that charge, if I may. Okay. You saw someone on the sidewalk, correct?
Yes.
Did you know who it was when you first saw him?
No, I did not. Not immediately.
Not immediately. Is that no? Yeah. Is that no?
No.
Okay. At some point, did you later determine who that person was that you saw on the sidewalk?
Yes, I did.
Okay. At what point was that?
Just some few minutes later.
And how did you determine the identity of the person you saw on the sidewalk?
I recognized him.
Okay. Now, you mentioned a moment ago that you felt uncomfortable watching the man on the sidewalk. Is that right?
Yes.
What did you do after you saw that person initially? Did you continue to watch him?
No, I didn't.
What did you do?
I turned away from the curtain,
Okay. Where did you go?
further into the bedroom.
Okay. Where was your husband, Carl Colby, at that time?
He was with me.
Okay.
at the window.
Did you return to the window?
Only after he went downstairs.
Okay, but at some point, you returned to the window.
Yes.
Okay. Where was your husband, Carl Colby, when you returned to the window?
He was going downstairs
Okay. Why did you return to the window?
because I wanted to know who it was.
And the second time that you went to the window, were you able to recognize the person you saw on the sidewalk?
Yes, I was.
Okay. Who was that person?
OJ.
The defendant?
Yes.
Now, how much time went by between the first time that you went to the window and the second time that you went to the window?
2 minutes, 1 or 2 minutes.
Okay. Now, the second time that you went to the window, was the defendant in the exact same spot that he was when you first went to the window?
No, he was moving slowly forward,
In what direction?
north.
Toward Nicole Brown's house?
Yes.
Now, you knew the defendant prior to that evening, is that correct?
Yes.
You'd met him before?
Mm-hmm.
Is that yes?
Yes.
Now, what was the defendant doing out on the sidewalk the first time you saw him?
He was thinking.
Objection calls for speculation, motion to strike.
The answer is actually non-responsive, so the answer will be stricken. Juries to disregard.
Well, what did you see the defendant do? What, if anything, was he doing that you could see the first time you saw him?
He was just walking along.
All right. And was he walking in a northerly direction the first time you saw him?
Yes, he was.
Okay. And the second time you saw him, was he still walking in a northerly direction?
Your Honor, I'm going to object.
Yes, he was.
Answer 3 times.
Overruled.
Did you see the defendant do anything other than walk in a northerly direction either of those 2 times?
No, I did not.
Did the defendant ever leave your view?
No, he did not.
Can I have 1 moment? After the first time you saw the defendant, at the time on which you didn't know who he was, did you call 911?
No, I did not.
Did someone call 911?
Objection calls for speculation.
Overruled. She can answer the question if she knows.
My husband prepared to call 911.
Motion to strike. Not responsive.
Overruled.
Did you see your husband pick up the telephone?
No, I did not.
How did he prepare to call 911?
Objection calls
He
for
headed
speculation.
downstairs.
Overruled.
And as your husband headed downstairs, you continued to watch the man on the sidewalk?
Yes, I did.
How long did the man remain on the sidewalk? The man you identified as the defendant?
All the time that my husband was downstairs,
Okay. How much time was that?
2 or 3 minutes.
Okay. Did your husband call 911?
Yes, he did.
What happened next?
I went to tell him that it was OJ.
You went downstairs to tell your husband that the man on the sidewalk was OJ, the defendant?
Mm-hmm. I did, yes.
Okay. And did you tell him that?
Yes, I did.
Did you look back out toward the sidewalk at that time?
I looked, I recognized him, and I went to tell my husband.
Okay. You went downstairs?
Yes, I did.
Okay. Is there a window downstairs, a window that faces Gretna Green?
Yes, there is.
Did you look through that window when you went downstairs?
No, I did not.
What did you do after you told your husband that the man on the sidewalk was OJ?
I went back upstairs,
And what did you do?
and I went to bed.
Okay. Did you ever look out the window again?
No, I did not.
Did the police arrive at your house?
Um, I don't remember.
Did you ever see the defendant walk up to the front of the house occupied by Nicole Brown?
No, I didn't.
Did you ever tell the police that you saw the defendant walk to the front of the house
No, I
next
did
door?
not.
Did you see the defendant's car at all?
Yes, I did.
Where was his car?
It was parked on Shetland Lane.
The defendant's car was parked on Shetland Lane.
Yes, it was.
Now, the front of Nicole Brown's house faces which street?
Gretna Green.
So the defendant's car was parked around the corner?
That's right.
Is there a driveway in front of Nicole Brown's home?
Yes, there is.
Is that a single-car driveway?
No, it's a large driveway.
A three-car driveway?
It's a two-car.
Okay. And are there places to park in front of the house, that is, at the curb?
Yes, there are.
The defendant didn't park at the curb in front of the house.
No, he did not.
He didn't park in the driveway.
No, he did not.
And when you say the defendant parked on Shetland Lane and around the corner, how far down the street, how far away from the intersection at Shetland Lane and Gretna Green did the defendant park his car?
One building beyond the corner.
Okay.
It was really in front of our building that he parked, and our building is very long.
And that's because your building has several units.
3, yes, that's right.
Do you know why the defendant didn't park his vehicle in front of Nicole Brown's?
Sustained.
No, I don't.
Well,
Had you ever seen the defendant arrive at Nicole Brown's house at night?
Objection.
overruled. It's foundational. We'll get, I assume there's some more questions coming behind you. You can answer the question.
No, but I wasn't often over there at night myself.
Okay. So you never saw him arrive at Nicole Brown's house at night? Is that
No.
correct? Okay. Did you ever see the defendant leave anything from Nicole Brown, that is, on her doorstep?
I'm sorry?
Did you ever see the defendant, O.J., leave anything at Nicole Brown's doorstep?
I didn't see things, him leave anything. I saw things that he had left, that Nicole told me he had left.
Did the defendant ever visit you at your home?
Yes, he did.
On how many occasions?
Only a couple of times.
Okay. Now, you have a son, is that correct?
That's right.
Okay. And your son played with the defendant's son, Justin, is that right?
That's right.
Did you ever talk to the defendant about his relationship with Nicole Brown?
On a couple of occasions, I did.
Let's talk about the first occasion. Where did that conversation take place?
Well, that took place in my kitchen.
How is it that the defendant found himself in your kitchen?
Well, Nicole wouldn't let him in the house at that time.
Objection, Your Honor. Also, there's
Sustained.
motion to strike.
That's stricken. Jury is ordered to disregard that last answer. Yes, let's see the court report, please. All right, thank you very much, counsel. Ms. Bowe, if you would you listen very carefully to the question that's asked and answer only the precise question that is asked of you? Also, if one of the attorney makes an objection after the question has been asked, don't answer the question until I rule on the objection. Okay?
Yes.
Great, thank you. Mr. Darden, you may continue.
Was the last objection sustained?
It's been so long, I don't even remember.
It was a very good question, Your Honor.
Yes, it was, because it was not a statement
Okay.
by the defendant.
Now, the reason that the defendant came to your home on those few occasions you just mentioned a moment ago, okay, how did you learn the reasons? Was it from watching something or from talking to someone?
That's what he told me.
Okay, that's what the defendant told you. Is that right? You have to answer out loud.
Yes.
Okay. The defendant, what did the defendant tell you? What reason did he give you for coming over to your house?
Objection.
Overruled.
He didn't have to give me a reason. The boys were back and forth. My kitchen door was open. I was working in the kitchen. He would be coming by to see Nicole and the children. He didn't tell me why he wasn't allowed in the house that day. He just hung out in my kitchen for a while.
Okay. Did he tell you that he wasn't allowed in the house that day?
Yes, he did.
And you would have conversations with the defendant, is that right?
One time I fed him a piece of peach cobbler. Another time we stood and talked. Yes, we had dialogue.
Okay. Did you talk about Nicole Brown?
I did not talk about Nicole.
Did the defendant talk about Nicole?
The defendant talked about Nicole.
Okay. What did he tell you? What did he say about Nicole?
That she wouldn't let him in the house.
Did he say
And
anything?
he told me that I had heard an argument between them prior to one of these occasions. And from what fragments I heard, she was angry at him about...
Please let her continue, Your Honor.
Next question, Mr. Darden.
You heard an argument between the defendant and Nicole Brown.
Yes, I did.
You could hear the defendant speaking.
My kitchen door was open. I could hear the defendant speaking. They were going through the driveway, which is right next to my back door.
And they were arguing.
Yes, they were.
And could you discern from what the defendant was saying what it was that they were arguing about?
Yes, I could.
What were they arguing about? Oh, that's good.
Come on over here to the sidebar with the reporter, please. Don't go away. All right, thank you, counsel. Mr. Darden, you may continue.
Okay. During the kitchen conversations you had with the defendant, what, if anything, did he tell you about the nature of his relationship with Nicole Brown?
He implied that she was upset over his womanizing, but that was in the past. The womanizing was in the past.
Is there a park located near your home?
Not on foot, but there is a park nearby, yes.
What's the name of that park?
Kenter Canyon Recreation Center.
Okay. Was there ever an occasion in which you had a conversation with the defendant at that park?
Yes, there was.
And do you recall when that was?
It was around the same time. In the spring.
Did you and the defendant go to the park together?
We went with our 2 boys and Nicole.
And while at the park, did you and the defendant have a conversation regarding the nature of his relationship with Nicole Brown?
That was part of the conversation. Yes, we did.
And what was the general subject matter of the rest of the conversation?
I was addressing what I recognized as his stress.
Okay. The defendant seemed to be under stress.
Yes, he did.
What caused you to think or believe that the defendant was under stress?
Well, he was arguing loudly, and also I saw a lot of the white of his eye showing between the lid and the iris, and that's an indication of stress. And I brought it to his attention at one point during the dialogue, and we talked about that.
Okay. Well, who was he arguing loudly with?
Nicole.
What was he saying to Nicole?
I gather that he was angry at her, thinking that she had been with another man, and she was angry at him for being angry at her.
Could you elaborate on that?
Well, after a while she wouldn't argue anymore, and she just fumed on a stone wall, so I was stuck with OJ.
Okay. And you had a conversation with the defendant then?
Yes, I did.
Okay. And tell us the conversation you had with the defendant at that time.
Well, he said that she was sleeping with somebody who had been staying at her house. And I was reluctant to discuss it. But because he seemed so upset, I felt I could put his mind more at ease by telling him that I didn't think she was. In fact, I was sure she wasn't because my boy was over for overnights, and Nicole had specifically told me that this individual was staying in the spare room. And when my son was there for an overnight, the next day I did ask him where he had stayed, where the guest had stayed. And my son told me that he had stayed in the spare room. But when I told OJ that, he scoffed at me as though to indicate that I shouldn't believe her. But I did believe her because she had never lied to me. I had no reason to think that she would ever lie to me. I couldn't convince.
Hold on. Next question.
Was the defendant upset or angry during that conversation?
Yes, he was very upset.
And were you able to relieve his stress somehow?
Eventually I was.
How long did it take you?
Well, I'm not sure I entirely succeeded, but maybe 15 or 20 minutes.
Why aren't you sure that you entirely succeeded?
Because he was convinced that I was mistaken, that he knew how things were.
Was the defendant and Nicole Brown living together at that time?
No, he was not. He was divorced at that time.
Thank you. That's all I have.
Mr. Shapiro? Certainly.
Good morning. I'm Robert Shapiro. I represent Mr. Simpson.
Good morning, Mr. Shapiro.
How are you today? How would you prefer that I address you?
Miss Bowe is fine.
Miss Bowe, because everybody has different connotations these days, and I don't want to insult you at all.
Thank you, Mr. Shapiro.
How long had you known Nicole Simpson in 1992?
I really became friends with Nicole Brown Simpson when she moved in next door.
Which was when?
So it was... I don't remember when she moved in.
Can you give us an approximate year or month?
Does somebody know when she moved in next door to me?
All right, let me go on to another question. Did you know O.J. Simpson prior to the time that Nicole Simpson moved in next door to you?
No, I did not.
And when Nicole Simpson moved in, she moved in at the time that she was going through a separation and later a divorce.
That's right.
And the incidents that you're relating to now in April of 1992 took place during the time that the divorce was pending, which was filed in about February. Is that correct?
I believe the divorce was final at that time.
In 92?
Am I mistaken?
Yes.
Objection, Your Honor. Mr. Shapiro going to take the stand?
Yes. I mean, it's a court record. I mean, if we're going to argue about the date of the divorce,
All right,
we're
counsel,
going to do
counsel,
it forever.
counsel, hold on. The date of the legal documents and the date of the divorce are not disputed. So, Mr. Shapiro, why don't you proceed?
Yes. The date of the divorce, she filed for divorce in February of 92, and the divorce was final 6 months later in October, or thereabouts, 8 months. To put that in perspective now, when you saw O.J. Simpson during this period of time, did you ever see him in the company of his son and your son?
Yes, I did.
On how many occasions?
A half dozen?
And did he ever accompany your son and his son to athletic practices?
Yes, he did.
So you would find nothing unusual about Mr. Simpson coming to your house at all, would you?
No, not at all.
And if he came to your house, would you find it unusual if he wanted to go next door and visit or talk to somebody who he was going through a divorce with?
Overruled.
Can you say that again?
Would you find it unusual that while he was coming to bring his son to play with your son, that he might want to stop by next door and talk to a woman who he was going through a divorce with?
You mean he would come by and stop by and talk with Nicole?
I'm saying, would you find it unusual if he came by with his son to visit your son, that he might, during that same visit, go next door and check in and see Nicole?
It would be unlikely that he would come to my house without going to Nicole's house, yes.
And during the time that Nicole lived next door to you, did you ever see any evidence of any physical abuse on Nicole?
No, I did not.
The individual that your son said was spending the night with Nicole the day that the night your son slept over?
Objection, Your Honor, that mistakes he was spending the night with Nicole.
Sustain. Rephrase the question.
You referred to an incident where there was a discussion about a gentleman being over at Nicole's house, and O.J. had some degree of being concerned about that and discussed it with you. Is that correct?
Yes,
Was that gentleman's name Keith?
yes.
And Nicole had told you that nothing happened between herself and Keith of any sexual nature.
Overruled. You can answer the question.
I can answer the question?
Yes.
Nicole told me that he slept in the spare bedroom. We did not discuss whether or not they were or had been or were becoming lovers.
And O.J. said that he was upset because he believed that there was some sexual activity in the close proximity of children, including your son.
No, I don't think he was concerned about whether it was in the proximity of the children. I think he was concerned of whether it was his wife.
On occasion, would you know O.J. to bring flowers by to Nicole?
I did see the flowers that he left for her and that he had delivered to her.
And on the particular occasion that you're talking about in April, before you realized it was O.J. Simpson and your suspicions were aroused, was there anything unusual about the way he was walking up to her house?
Unusual?
Yeah.
Probably the only thing unusual about it was that it was 11:30 at night.
And you don't know whether Nicole was home or not, do you?
I assume Nicole was home.
And you don't know whether he had been invited to come over or not, do you?
No, I don't.
And he wasn't dressed in any unusual way, was he?
No.
Didn't have any hats on or any disguises on?
No.
And as far as parking the car, let me mark two photographs, if I might, for identification, please, Your Honor.
Sure, without the report on. All right, noted. Thank you, counsel.
Your Honor, may I show these photographs to witness, please?
You may.
Thank you very much. Excuse me. Ms. Burrow, can you identify these two photographs for the jury, please?
Yes, I can. This is my house here, which is on the corner of Gretna Green and Shetland Lane. Here is Nicole's house, her driveway, and here's the little stone wall. My kitchen door is in the back there. The boys would be back and forth across the wall.
This photograph is identified. I don't have my glasses on. What's the number on this?
P24.
And the second photograph?
This is Nicole's house with the garage door closed.
And would you identify that photograph?
P23.
Now, P23 is directly in front of Nicole's house.
Yes, it is.
Shows cars right in front.
Yes.
Now, there are large trees there, are there not?
Yes, there are.
And are those the type of trees that tend to drop a lot of berries and other types of residue?
Well, those are bottle brush trees, and they have big red blossoms like brushes.
Do you know that there may be some people who prefer not to park nice cars under trees that have a propensity to shed?
No, those are jacaranda trees.
Well,
The
we're getting a great
trees-
lesson in trees here today.
The jacaranda trees are actually in front of my house.
Well, if somebody didn't know the difference between those trees, and somebody took great care in their car, do you think they might have a little bit of anxiety about parking there?
I think they might have anxiety about parking on that street because Gretna Greenway is a through street, and you might not want to park your car on a through street.
Thank you so much for joining us today. I appreciate it.
Do you want to show the jurors those photos?
Yes.
I was going to put it on.
All right. Mr. Darden, redirect.
Very brief. I had Mr. Fairlow, People's 24, and asked him to put it up on the screen.
All right, and Ms. Bowe, there's a monitor right to your right there. Do you see that?
Yes, I do.
All right.
Now, the house on the left, is that your home?
Yes, that is.
Okay. And the house to the right of the photograph, that would be 325 South Gretna Green.
That's right.
Okay, there's a nice big driveway there, is that correct?
That's right.
Showing you People's 23. Okay. There are two cars parked there in front of 325 South Gretna Green, is that correct?
That's right.
Do you know who owns those cars, who they belong to?
No, I don't.
Did you ever see the defendant park his car in the driveway
Yes, many times.
directly beneath that big tree Mr. Shapiro alluded to?
Well, I saw him park in the driveway, which isn't directly beneath the tree, and I saw him park on Gretna Greenway in front of the house sometimes as well.
How many times did you see him park on Shetland?
Several times.
And that would be around the corner, is that correct?
That's right.
And on those occasions that he parked his car on Shetland, was there room for him to park his car in the driveway in Nicole?
Well, I can't remember every occasion that he parked on Shetland Lane. There may have been, there may not have been.
Sometimes it was, sometimes it wasn't.
Sometimes she parked her car in the garage. Sometimes she left it in the driveway.
Thank you, that's all.
Mr. Shapiro?
No further questions. Thank you very much, Ms. Bowe.
All right, Ms. Bowe, thank you very much for coming in. Please
Your
don't
Honor.
discuss your testimony with anybody
I
else
won't.
except to the lawyers until the end of the case. All right,
Yes, sir.
thank you very much, ma'am.
Good day.
All right, Mr. Darden, your next witness, please.
And one more, John.
Certainly.
Your Honor.
All right.
Sir, can you please raise your right hand? You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please have a seat in the witness stand and state and spell your first and last names for the record.
My name is Carl Colby, C-A-R-L-C-O-L-B-Y.
Mr. Darden.
Mr. Colby, the witness that just testified a moment ago, that's your wife, is that correct?
Yes, sir.
Now, sir, throughout 1992 and 1993, were you living in a home located at the intersection of Shetland and Gretna Green?
Yes, we were living on the northwest corner of Shetland and Gretna Green.
Okay.
Two-story house, cheek to jowl with 325.
Okay. So Nicole Brown's home was directly next door to yours during April of 1992, is that correct?
Yes, sir.
Okay. And you have a son, is that correct?
Yes, we have a son now 6 years old who was in school with Justin Simpson, OJ's son, and they were best friends, and they saw each other constantly. And when they moved in, actually, next door, it was a big surprise and a terrific event because two friends who went to school together were now living side by side. So they saw each other nearly every day.
Okay. And you became acquainted with the defendant here, is that correct?
Yes, sir.
And you became acquainted with Nicole Brown?
Yes, more with Nicole Brown because she lived there and we would just have more encounters with her.
When did Nicole Brown move into the house next door, if you know?
I believe it was in the beginning of 1992.
January 1992?
Yes, sir.
Okay. And when she moved into the house, did the defendant move into the house with her?
No, he did not.
Now, directing your attention to the last week of April 1992. Did you have an occasion to call 911?
Yes, I did.
And what caused you to call 911?
Well, it was an evening, approximately 10:30 or 11 o'clock at night, and it's a residential neighborhood, very quiet. And sometimes before retiring, I just go check the locks and look around downstairs, make sure the lights are off, things like that. And I happened to look outside, and I saw a man outside on the sidewalk.
And what was that man doing?
He was standing on the sidewalk looking at what apparently was the residence next door, directly to the north of us.
And what time of the night was this?
I'd say it was approximately between 10:30 and 11 o'clock that night.
Okay. So the man was standing on the sidewalk.
Yes, initially, when I first spotted him, he was standing about 5 yards south of the driveway and relatively stationary looking at the house. And then, since I saw him, I was curious, and I didn't recognize him. So I thought to myself, what is a man of this description doing outside at that time? So,
Sustained. All right, Mr. Darden, next question.
So you became curious.
yes, I was curious.
Okay. And did you continue to watch the man?
Yes, I did.
What did you see the man do?
I saw him observe the residence next door and then walk around the corner, which would be southerly and then westerly on Shetland, and then go back around again and look again at that residence. And I was a little bit concerned because...
Okay, well, let me just stop you there.
All right.
So that is clear. When you first saw the man, he was on the sidewalk 5 feet from Nicole Brown's driveway.
I'm going to object to Mr. Darden, even the witness's testimony. His testimony is very clear.
Actually, it misstates the answer.
It was
Rephrase
5
that
yards.
first.
5 yards. Okay. And then he walked back around the corner?
Yes, and then he walked on a southerly direction and then back around the corner. Our house is on a corner like this. So then went
Okay.
southerly and then westerly and then back around again.
Okay. And did he walk back to the same spot he was in
Yes,
when
he
you saw him
did.
initially? How many times did you see this man walk within 5 yards of Nicole Brown's driveway and then walk back
Well,
around
just those
the
two
corner?
incidents.
Okay. And were you concerned at all?
Well, I was concerned because first of all, I didn't...
Your Honor, it's been answered.
I asked if he was curious before.
He asked if he was concerned.
Well, I
He said
thought
yes.
that the-
Well, hold on. When there's an objection, Mr. Colby, if you would, allow me to rule on the objection, and if it's okay to answer the question, I'll tell you that, all right? You've answered the question, were you concerned? The answer to that question is either yes or no. You've answered it yes.
The answer is yes.
All right. Next question, Mr.
All right.
Darden.
What did you do after you saw the man return to a point within 5 yards of Nicole Brown's
Well,
driveway?
I thought that the man might be a...
Okay.
Correct.
I
All right,
called...
hold on.
Okay. Well,
Listen,
what-
Mr. Colby, I realize you're not used to doing this every day. Listen very carefully to the question that Mr. Darden or Mr. Shapiro asked you and answer that precise question, please. All right, Mr. Darden.
okay. What did you do after you saw the man return to the driveway?
I called 911
Why did you call 911?
because I felt that the gentleman in question could be a possible burglar or intruder to my residence or to one of the residences in the neighborhood.
Now, after you called 911, did you continue to watch the man?
Yes, I did. And when I called 911, I told him that it was not an emergency.
All right. Please Just answer the question. Thank you.
When you called 911, did you continue to watch the man?
Yes, I did.
Okay. What did you see the man do after you called 911?
He went back to the original position and looked at the residence, and then left.
Now, as the man left, did you recognize him?
Yes, I did. After I'd made the call, I recognized him.
And who was that man?
It was Mr. Simpson.
Did you ever see the defendant approach the front door at Nicole Brown's home that evening?
No, not that evening.
Did you ever see Nicole Brown that evening?
No, I did not.
Could you see Nicole Brown's driveway at all that evening?
Yes.
Was her vehicle or her car parked in the driveway?
I don't remember. I don't believe it was.
Did you see the defendant's car in Nicole Brown's driveway?
No, the defendant's car was around the corner
And how do you know the defendant's car was around the corner?
because I saw him drive away.
Did you see him walk around the corner?
Yes,
Did you see his car parked around the corner?
I only saw it drive off.
And the corner you're referring to, that would be Shetland, is that right?
Right, into the cul-de-sac.
I believe you indicated before that your home is located at the intersection at Shetland and Gretna Green, is that correct?
Yes, sir.
How far down Shetland Lane, how far away from the intersection was the defendant's car the first time you saw it that night?
Approximately 50 to 60 yards down. I saw the car as it departed.
Okay. Now, what did you do after you realized that the man you saw looking at Nicole Brown's home was in fact the defendant?
Well, I was embarrassed that I'd called 911 because I didn't feel that Mr. Simpson was a threat to me or to anyone else in our neighborhood. So I did not call the police back because shortly thereafter the police did appear and I told them who it was and what the nature of the incident had been.
Did you have any conversation with the defendant prior to him leaving?
No, I did not.
Had you ever seen the defendant arrive at Nicole Brown's house late in the evening and just stand on the sidewalk?
No, only that one incident.
Did you ever see him outside in front of Nicole Brown's house late at night?
No, I did not.
If you know, what was he doing that night, the night that you saw him and called 911?
No, I think you can describe what he observed. Oh, well,
What was he doing?
He seemed to be hesitant and to be attempting to perhaps observe something that may have been occurring within the house, but he never took action and stepped onto the property of the house, or he didn't do anything untoward.
There's a big picture window in front of 325 South Brentwood Green. Is that correct?
Yes, sir.
We can put People's 24 in the Alamo, Your Honor.
all right, 24. And Mr. Colby, right to your right, there's a monitor for you to look at what's being depicted.
Yes, I see it.
Mr. Darden.
Where do you see the picture window? Where? Just take a look at the monitor. Where is the picture window located?
The picture window is far right-hand side in the shadow of the trees, to the right of the driveway.
Okay. Thank you. And you can see through that window from the sidewalk, can't you? Or do you know?
Conceivably.
Thank you. That's all I have.
All right, Mr. Shapiro?
Good afternoon, Mr. Colby.
Good afternoon. How are you?
I'm Robert Shapiro, one of Mr. Simpson's lawyers, and I have a very few questions for you this morning. Do you know whether or not O.J. Simpson was simply waiting for Nicole Simpson to arrive that night and meet her?
I have no knowledge of that.
Do you know if she was home?
I don't know that either.
Do you know if they had any prearrangements that night?
No.
And as you say, you were embarrassed by the fact that you had called the police because really there was nothing suspicious.
Overruled.
Can you repeat the question again?
You were slightly embarrassed that you had called the police when you realized it was O.J. Simpson because there really was nothing suspicious that evening.
Well, I can't speculate as to whether it was suspicious behavior or not. All I've said is that I observed the party on the sidewalk.
And just a final question. One of the lawyers from my office, Sarah Kaplan, called you, did she not?
I don't remember that.
And, do you recall last week called and asked to talk to you about your observations? Do you remember her or not?
I think so.
And you told her that you wouldn't speak with her?
I believe I did say I didn't speak to her.
Was she rude in any way to you or offensive in any way?
No, but no.
Thank you. Nothing further.
Mr. Darden, any redirect?
Why is it that you refuse to speak to Sarah Kaplan?
I felt that to come forward and to speak to you, Mr. Darden, and to you, Ms. Clark, was appropriate behavior, and I don't attract the attention of the press or of any other party.
By the way, that night, the night in which you saw the defendant in front of the house, did you know that Nicole had filed for divorce?
Yes.
Mr. Shapiro?
Thank you.
All right,
Thank
Mr.
you.
Colby, thank you very much for coming. Please don't discuss your testimony with anybody else except the attorneys till the case is over.
I will. Thank you, Judge.
Thank you very much. Mr. Darden, your next witness?
Any chance we can have 5 minutes break, Judge?
I'm getting the signal the jurors want a 5-minute break. All right, let's take a quick 5-minute break. Witness. All right, with the reporter, please. All right, ladies and gentlemen, I have 1 or 2 other legal matters I need to take up out of your presence. Since we're 5 minutes to noon, I'm going to send you out to an early lunch. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to talk to you about the case. Don't conduct any deliberations until the matter has finally been submitted to you. All right, Deputy McNair, let's excuse the jury, but we will go back into session briefly for a few discovery matters. Parameters for those missing articles, correct?
Yes, and that is being done. We informed the people early this week that we, in fact, had done an extensive search and had compiled what we believe to be every public statement made by Denise Brown regarding this case, and we do not feel that we have any legal obligation whatsoever to inform the prosecution of this, but in a spirit of cooperation and good faith, and in a spirit of trying to save time, because I feel that I will be using these documents for cross-examination, that the people will have adequate time to get ready.
All right, counsel, I appreciate your having already made a copy. Save my staff some time.
Thank you very much, Your Honor.
All right, I'm going to order the prosecution, since these are otherwise copyrighted materials, not to make any further photocopies of that. They may not be copied or otherwise disseminated, and they're to remain in your possession, Mr. Gordon, or possession of the prosecution team.
Yes, Your Honor, we're awaiting the other data search, and we'll conduct it as soon as we get it.
All right, but given the parameters of what's left of our court day, I suspect we won't even finish direct examination today. So you'll have the weekend to peruse those matters. All right, anything else we need to put on the record before we take our recess for the noon hour? No? Terrific. All right, and Mr. Shapiro, you're excused. Was that another beeper?
Thank you very much. I didn't know, Your Honor.
Whose beeper was that?
Suspects.
I don't have one, mine upstairs.
Okay, that's not hot. That was by you.
All right, Mr. Shapiro, you're excused until 2 o'clock.
Thank you very much, Your Honor.
All right, we'll stand in recess until 1:30, discovery matters and other remaining motions at 1:30. All right, thank you, counsel.
They have indicated, I believe, around January 4th, when we were provided with the DOJ reports, that they were done testing. We, at that point, began discussions about getting access to the exhibits so that we could conduct our own independent examination. I would indicate to the court that under the Sixth Amendment of the U.S. Constitution, Mr. Simpson has a right to effective assistance of counsel, and in fact, we have an obligation to provide that effective assistance to him. Fundamental to that right is our obligation to examine all of the evidence that might be used against him. And we must be able to do that in a meaningful manner. Right now, up to this point, we've only had access to this evidence from afar. When Drs. Bodden and Wolf were allowed to look at exhibits, they were instructed that they were not allowed to touch anything, they were not allowed to take anything out of any bags, they were not allowed to do any photographing. This is obviously one of the reasons why there are no reports from those people, because they would not prepare reports based on that kind of a cursory examination. That is not a meaningful examination from our standpoint. Proposition 115 requires that we make available to the prosecution any scientific reports, evidence examinations that we intend to use. While 115 imposes certain obligations on us, it also creates certain protections for us. We are not required to turn over expert reports or investigative reports that we do not intend to use in our case. And the reason for that is so that we can conduct an effective investigation. We may find some things that we don't like and we don't want to use, and that's our right to not use those things, and we don't have to turn them over to the prosecution. To allow a prosecution expert to be looking over our shoulders, as you will, while we conduct scientific testing is, in a sense, requiring us to make disclosure to the prosecution of the results of all examinations that we do, whether we like the results or not, whether we intend to use the results or not. I would point the court to the case of Prince versus Superior Court, which is at 8 Cal App 4th, 1180, which I believe the Court's already familiar with. That case involved a situation where there were two vaginal swabs, and the Court ruled that the defense had a right to one of those swabs, since the prosecution would have the other swab and could do whatever testing they wanted to do on that swab, and that the defense would have the right to conduct independent testing out of the presence of the prosecution on the remaining sample. The basis for that ruling was the Sixth Amendment, effective assistance of counsel. I would also point out that under Code of Civil Procedure 2018, which is the work product statute, the policy of that section is to preserve the rights of attorneys to prepare their cases and to prevent attorneys from taking undue advantage of an adversary's industry and efforts. And I would submit to you that testing that might be done by our experts at our direction are certainly work product under that guise until the point where we decide that we're going to submit something to the court or to the jury, at which point the prosecution has a right to have that. I might also add that we were not permitted to be present when this evidence was collected. We were not permitted to be present when it was transported or when it was initially prepared for analysis at Piper Tech with the LAPD people. While we have been allowed to watch while some of the DNA testing has been done, we have not been allowed to do any testing on our own. The court has, up to this point, has been unwilling to impose any kind of timeliness requirement on the prosecution. They've had this evidence for an extended period of time. I believe in your order, your ruling on the Griffin hearing, you pointed out that the defense should use or the prosecution should use all conservative methods in order to preserve possible samples for testing by the defense. And we're at a point in time now where the trial has already started. We would like our opportunity to examine this evidence, and if we decide that we want to conduct a specific test, we think we have a right to do that in private and not reveal the results unless we decide that we're going to use those results. So with that, I would submit the matter and ask that we be allowed to, that the exhibits be provided to us as soon as possible, and that we have no objection to them being there while we open them up and look at them, and they can videotape that if they like. But at a point in time where we decide that we want to do a specific test, we submit that we have a right to do that in private.
You have no objection to the presence of the custodian of these items being present when they're displayed, examined, splits are taken, but for the actual testing, you want that done in private?
That's correct.
All right. All right. Are there any unusual items here, Mr. Blazier? You have the lists, the numbers that you list on page 2 of your letter. Are there any items that are of unusual difficulty in handling?
I don't believe so. I think most of the, or a lot of the items have been already tested by the prosecution. We did not ask for large pieces of the Bronco. That might be troublesome to transport back there. All of the coroner's exhibits are all relatively well contained and ample quantity that if the prosecution wants to do further testing, presumably they could. So I don't think that there's anything that requires any kind of a special order.
All right. Thank you, counsel. Good afternoon, Mr. Harmon.
Good afternoon, Your Honor. It's funny how we can live through the same events and have a different appreciation for them.
Well, there's a jury instruction on that.
This is all not in front of the jury, so. A little history, I think, is in order. On November 28th, we wrote the court and told the court and counsel that the socks and the glove were back here, and if you wanted to do any sampling or examination, feel free to. We just wanted to videotape it. And in light of Mr. Cochran's opening statement, I'm just thankful that they didn't take us up on that for reasons that will become obvious in a few minutes. So some of these items, and those two in particular, have been here for months, and no one took us up on that. Much to our surprise, on January 9th, we got a letter from the defense team saying they wanted all their lawyers to go visit the lab the next day. And, you know, those are not easy arrangements to make. And then they also said that they wanted designated items to be sent to Dr. Lee in any fashion we desired. And they never designated them. And that's when I made the mistake of doing something that I had tried not to do in this case. I tried to discuss this with Mr. Scheck, and if you recall, when we went on the record after that, I asked Mr. Scheck that whenever we had any communication, let's put it in writing so our memories can't fade and we can't forget what really was discussed. So this latest letter is, or actually we responded to that January 9th letter on January 9th, and we said, and this is a quote, "We are in receipt of your letter of January 9th, 1995. You have not provided us with adequate time nor given us sufficient information to intelligently respond to your requests. Please file appropriate legal motions with the court." January 9th. Nothing happened. January 30th, 3 weeks later, we get the letter that brought us here today. And much to my surprise, the letter says that Mr. Clark and I agreed to something. Now, we agreed to something when full information was provided. At that time, Mr. Scheck suggested that we abide by the rules of Cellmark. And if you recall, this was long before I was involved in the case. Cellmark would allow defense experts to view testing. And we were very surprised that, that something like that would be so easily resolved between Mr. Scheck and I. And then nothing ever came of it until we read this letter reading that we had agreed to shipping everything, when in fact no numbered items had ever been mentioned in any of those conversations. If there was ever any agreement, it was that our experts would be allowed to watch, to videotape the samplings, examinations, and tests, just as we have allowed the defendant to do at every turn in this proceedings. The ubiquitous Dr. Blake, the ubiquitous but invisible Dr. Blake, continues to visit the Department of Justice. And this is done very cordially by them. They tell him when things are going to happen and change their schedule so that he can show. I think it's at this point we need to reflect back on something that I watched at home on television back in August, not realizing I'd be here. Ms. Clark offered to have the ubiquitous Dr. Blake do all of the testing, all of the PCR testing that apparently, and I say apparently, is now being requested of this court. I'm somewhat surprised to hear Mr. Blazer, perhaps he hasn't been informed of this, and if he hasn't, it's another curious event, say that they've never had any of the evidence, when you know, Your Honor, that you signed an ex parte order way back in October for items 47, 50, and 78. And those items were released to the defense team. Mr. Blazer apparently doesn't know that. Perhaps this is another one of these instances where they've tested something in secret and they don't even want him to know what the answer is. It's clear that what they want to do is hide the ball. And I'm going to convince you today, Your Honor, that on many of these items the time has come to realize that this is not about finding the truth that's in that physical evidence. And physical evidence is a totally different category of evidence in this state. That this is only about winning at all costs. The defendant has requested 184 items, most of the physical evidence in this case, to be transported to a laboratory on the East Coast right when we're in the middle of our case, or I shouldn't say middle, but right when we've begun our case. Some of them are really interesting and intriguing items. Now, they haven't said what they want to do with it. They haven't said what kind of tests they want to perform on it. And I think there are legal reasons why they have to specify that I'll address. They want I've picked out some of the more intriguing items. Item number 118. It's a knife that Mr. Cochran had up on Greg Matheson's report. It's a knife with someone else's blood on it, other than the victims. That's one of the knives or one of the items they want to see. They want number 136, which was seized from Ronald Goldman's apartment on June 15th. Dino, the autobiography or biography of Dean Martin, for some strange reason. They want number 143, a knife found all the way down in Oceanside. Perhaps the most interesting item that they've...
Oceanside, as in San Diego County?
That's right, Your Honor.
Okay.
They must know something that we don't know. The item that I found most intriguing and interesting is they want number 200, a cassette was seized from Mr. Simpson's Bronco, Carlito's Way, the soundtrack. And all I could think of was perhaps they want to play it backwards like the Beatles' I'm the Walrus. And if you do that, remember you hear Paul is dead, there'll be a clue as to who really killed the victims in this case.
You're dating yourself.
It should be obvious.
And Your Honor, you seem to understand it also.
Among the list of items are some items that are still being tested at Department of Justice. This list was done very carelessly without any real consideration for what we have already told them. Items 79, 81, and 86, they're at the Department of Justice. They know that. We've told them that.
What are those items?
They are clothing items belonging to Ronald Goldman and Nicole Brown. I can't sort them out now. I don't quite have them memorized yet. In 303 and 304, and this is not inclusive, but I'm pretty sure it is, those are some stains from the Bronco that were collected the second time around, I believe in August. Those things are still at the Department of Justice, and we've told them that all along. No specific reason is provided for any of these items. No specific test is mentioned, and there are legal reasons why it's incumbent upon them, in my opinion, to provide that kind of specificity. So the defendant now wants all of these 184 items to be shipped off to the East Coast. What's interesting about the timing of the request, Your Honor, it's made immediately after Mr. Cochran has publicly accused the prosecution of conducting unreliable DNA tests on contaminated samples, the same time he's accused someone in law enforcement of planting Nicole Simpson's blood on the defendant's socks. Because defendant or his team apparently seeks to perform tests which consume or alter some of these items of physical evidence forever, they have to justify, under the authority of People versus Cooper, what these items are, why these samples are needed, and who will perform the tests. If the DNA tests are being contemplated by the defense, how have those tests suddenly become reliable in their hands when Mr. Cochran has announced to this jury and the world that they're unreliable in their forensic application? Perhaps they're contemplating having Nobel Prize winner Mullis perform some of his cyberspace 21st century tests on these items. And hopefully, I add this parenthetically, hopefully the court will allow the people, when we cross-examine Dr. Mullis, to engage in some of the probe and questioning that Ron Shipp underwent in terms of his consumption habits and his bizarre scientific opinions. If Mullis performs these analyses, it will be the first time he's ever tested forensic evidence. Somehow, perhaps the defense has suggested that the way Mullis will do it will overcome the technology transfer point that Mr. Cochran alluded to in his opening statement. Well, because of those shocking allegations, specifically with respect to Nicole's blood on the defendant's socks, which Mr. Cochran made public for the first time on Monday, the prosecution presently intends to perform tests on those blood-stained areas of defendant's socks which are able to detect the presence of the preservative in reference samples, in the sample that was preserved by the coroner. There is a preservative named EDTA in those tubes. They're pre-manufactured. There's a specified amount of that preservative in those tubes. We intend to pursue that with all of our vigor to refute the allegations which have cast a cloud over many of the people who worked in this case. Had these allegations been made months ago, we could have done this months ago. But for whatever reason, those ugly rumors circulated and circulated, and then finally on Monday, Mr. Cochran pointed the finger. Unfortunately, when he pointed the finger in his sock timeline, he left out one important event that totally undermines the chronology that he created or demonstrated in front of the jury. And the event that he left out was before that leaked story, the LAPD had done conventional screening on that sock and determined that the PGM subtype belonged to Nicole and did not belong to any of these other people. So it was known. That doesn't mean that it didn't appear that there was a leak, but that's an important part of the story that Mr. Cochran left out. We are under a legal obligation, in light of these allegations under Brady versus Maryland, to pursue this issue. Not that we believe it will produce exculpatory evidence, but we have an obligation to do so, and we intend to do so with all the resources that may be available to us. And we also have a moral and an ethical obligation to pursue this. And this isn't any inquiry motivated by advocacy. This is a purely scientific inquiry. We can't rely on tainted evidence. We have no doubt that the blood on those socks, which we have identified conclusively through multiple DNA tests, belongs to Nicole and was transferred there during the savage, brutal killings of Ronald Goldman and Nicole. We have an obligation to those people whose reputations stand to be tarnished by Mr. Cochran's careless charges with no substance to them. The tests will show that the blood on those socks, which Mr. Cochran admits is Nicole's, did not come from the reference sample that was laced with EDTA that was obtained by the coroner's office. It's a question of scientific truth, which can only be addressed by fair and impartial scientists, not attorneys whose interests are irreconcilable or whose careers serve to be promoted or advanced by careless charges such as that. In fact, we've invited and we continue to invite input from the scientific community about how to approach these tests and to design them in a way that there will be no question that when those tests prove that there's no EDTA on the stain that's been identified as coming from Nicole, there will be no question. No one will have a lingering doubt. Right now, we actually invite the defendant to join us in this search if they want to find out what the truth is about how those stains got there. Perhaps we can agree on a series of different tests to be performed by different labs, overseen by a mutually agreed upon blue ribbon panel. If this is about finding the truth, we'll agree. If it's about winning at all costs, we won't. There are only two possible outcomes to this test. There's either going to be EDTA there or there's not going to be EDTA there. And we're willing to accept the outcome, whatever that is. One can only imagine the only reason the defense might not want to join in mutually agreeing on this is because they already know there's no EDTA there, and they already know how that blood got there. We agree to accept those results in advance. We sincerely hope that the defense agrees to do so too. And we especially hope that should we prove conclusively through a series of tests, well-established tests in the scientific community, the defendant will not fall back on the dated legal artifice of People versus Kelly to try to prevent the results from being presented to this jury. That kind of tactic would only subvert the truth even more. I believe at this point we have demonstrated that those socks need to be maintained in our possession until we have had an opportunity to pursue this scientifically. That includes all the reference samples. And I'm broadening this a little bit too to include the other two reference samples for reasons I'll allude to. If we're forced at this point to turn over any of those items of evidence, that could compromise our ability to produce a definitive answer about the presence or absence of EDTA on the stain that's been conclusively identified as coming from Nicole on the from the socks found in the defendant's bedroom. No court should force us to part with those items at this point. In Mr. Detective Van Adder's pocket, going to another side of town, and he never pointed out what stains might have been polluted or planted by Detective Van Adder. There's a reason he didn't do that, but that specter, that image is still floating around of Van Adder driving across town rather than taking the short route. There's a reason that he wasn't specific, and that is because all those evidence stains were collected before the reference sample had been obtained from Mr. Simpson. But still, in light of that misleading impression that was created, we want to maintain possession of all three reference samples, and they exist in tubes, they exist in cards, they exist in swatches.
So let me ask you this.
Yes, Your
As
Honor.
to those reference samples,
The defense has
three
already gotten samples
splits.
from them. I'm sorry.
all right, okay. Then I won't concern myself with those.
Yeah, they have already, I could pull out the dates, but the defense has already had access to the reference samples, all three of them. So there, in my opinion, there's no continued need to obtain those items.
Are there any items on this list that you're willing to concede that they're entitled to have in their possession for testing and you have no further objection?
Well, how about Dino and Carlito's Way, for starters? We made progress this afternoon. Well, I think it's incumbent on them to specify what it is that they need. And when I finish in a moment, I think you'll see the reason why, Your Honor. Under the authority of Keenan versus Superior Court, which we list in our letter, we have a legal right to observe these tests, not only to observe them, but to maintain the integrity of the evidence. That's at 126 Cal App 3rd, 576. Defendant, there's no surprise that they should rely on Prince versus Superior Court. I think the court needs to look at what our Supreme Court has said, People versus Cooper, 53 Cal 3rd, 771. They simply assert that this kind of monitoring would violate the attorney-client privilege and work product privileges. And remember, a couple months ago, we went through some discussions about attorney-client privilege and work product privilege. People versus Cooper, in my opinion, disposes of that. But, and if it doesn't, it's incumbent on them to point out by specifying what it is that they want to do and how much that they're going to consume. You know, if we just ship all this stuff off under their theory, it disappears into the black hole of Calcutta, and we never get to see or find out anything that comes out of it. I've just sent a letter to the defense team today. I want to know what's happened to 47, 50, and 78. We're entitled to present and account for the chain of custody. And I wasn't that actively involved at the time they obtained possession of it, but I think we're entitled to know that. What's left? You know, there have been serious allegations about how terrible the cesspool of the LAPD SID is, and we're entitled to clear those up by demonstrating that everything is accounted for. Remember the time or the chart about Mr. Simpson's reference sample? They've made some serious charges about that, and we're entitled, but if we give them stuff and are never able to account for it, I mean, there are two different issues. There's the chain of custody, and then there's the mandate. To me, the precise legal question is, what legal authority do they have to shield those results? That's our evidence. And we're more than happy to let them be as effective as they can be. But the law in this state and in this country doesn't allow them to be any more effective than the physical evidence allows them to be. And there's the bind. They want to take our evidence, they want to do some testing somewhere, and they haven't even told us that's where the testing is going to be. It is my opinion that the lab that we'll be shipping it to is merely a conduit to prevent us from, what good does it do to tape this and film this in one place if it's going to be shipped out all over the country from there? How are we ever going to be able to account for things? You know, juries ask, I'm sure you've seen some strange questions. They want to see things sometimes. And where are we when we say, well, we shipped it all off to them? I'm sure that they'll probably object to any reference to them having had access in the actual trial, too. I'm trying not to predict the future, but you know that's coming, too. That not only, if they prevail on any of these issues, not only do they reserve the right to attack our evidence, even if they've gotten the same answers, as they surely will in this case, but then they'll try to prevent any reference to the fact that they got the stuff in the first place, seriously misleading the jury and depriving us of any opportunity to show them that this is merely about criticizing what our evidence shows, but not about showing that the answers are inconsistent. And I just close on a practical matter. You know, the trial's begun. You can imagine what's going to happen when we say, can we have the glove? We're going to need it about 10 o'clock tomorrow, and then they have to track it down. So at this point, Your Honor, I see three categories. I see the socks and the reference samples. I see all the items of biological evidence that we may intend to pursue once we pursue the question on the sock, the question of, is there any EDTA in any of the samples that we've associated with Mr. Simpson? And what's interesting, there aren't that many samples that we've associated with Mr. Simpson that have a purely sinister implication to them, except for the crime scene drops. There's blood in his Bronco, there's blood at his house, and there's also his blood, which has been identified on those very same socks, too. But Mr. Cochran has raised the specter that Detective Van Adder or some other dark agent of his did something with Mr. Simpson's reference sample and planted it somewhere. And depending on how the first set of EDTA tests are done, and I can't even give you a timetable on that, Your Honor, we've been making many phone calls since Mr. Cochran made that announcement to the world the other day. But we reserve the right to be able to try to detect EDTA or determine that there is no EDTA in many of these other samples, too.
All right. Mr. Glazer?
Yes, all right. I'm not going to talk about Mr. Shipman or Carlito's Way. This is absolutely ridiculous. We've made allegations that maybe some of this evidence was tampered with, and now they're saying we can't even look at it to try and demonstrate that. Just because of what our defense happens to be doesn't give them legal authority to say we can't look at the evidence at all anymore. The only authority that Mr. Harmon cited is People v. Cooper, and Cooper does not say that we have to tell them what our tests are going to be, that we have to tell them when we're going to do it, that we have to tell them how much we're going to use, and that we have to tell them what the results are. What People v. Cooper says is that where a sample is so small that both sides can't do testing individually, that it has to be done together. That the defense does not have a right to deprive the prosecution of doing testing by doing it themselves and destroying all of the evidence. That's all that Cooper says. Prince came after Cooper and said that that's what Cooper said, but with Prince, where there's additional materials for the defense to do testing, they have a right to do it, and they have a right to do it in private. Mr. Harmon seems to be forgotten that we have a constitution in this country that provides that the defense has certain rights, that we have an obligation, that there's attorney-client privilege, that we're not required to provide information that might incriminate our own client if indeed that is out there, and that we have a right to conduct our investigation in a way that best allows us to prepare our defense. If Mr. Harmon is here to say that the fact that the socks, that there was an announcement to the press that Nicole Simpson's DNA were on those socks while they were still in the crime lab before they'd been sent for testing, if they can't figure out from that we might make some allegation that when the blood later on turns up on the sock that might have been tampered with, then they aren't very good trial lawyers. Certainly they knew that that was a possibility. Now they're trying to tie up that piece of evidence by saying they're going to do other testing which I don't know has passed Kelly Fry. I don't know whether it's admissible or not. They want to tie that up now so that we can't look at that. With respect to the items that they did tell us that they were still doing some testing on, we have no objection to letting them finish that and then have us look at it. The reference samples, we are interested in examining the tubes. If there was tampering with the tubes, we want to look at the tubes and the labels. We're not so concerned about the blood that's on the inside, but on the manner in which it's been preserved in the tubes and in the envelope, and that's what we would like to inspect with those things. Mr. Cochran pointed out in his opening statement that there had been some conventional serology done on those socks. It was the fact that it was announced that there was DNA testing that had been completed when they had never been sent to the lab that we felt was suspicious and is part of our defense and certainly is a legitimate part of our defense. I would just close by saying that if the only authority Mr. Harmon has is Cooper, it doesn't support what he has told this court that it says. It does not say that we have to tell them what we're going to do, how much we're going to use, where we're going to do it, and how we're going to do it. We apparently offered to have Drs. Wolf, Baden, and Lee assist the prosecution's experts in conducting tests early on. They were not particularly interested in that, and now we have a right to do the testing ourselves so that we can prepare our defense.
Why do we have to do this examination and split in New York? Why can't you have your people come here, do the physical examination, take whatever splits are agreed upon by both sides here, and then transport on your own those splits for testing?
Some of the examinations that we want to do are probably going to be microscopic examinations of items to determine whether we need to do any testing. That is done in our lab by our people with their equipment. We have no objection to them watching that so that they see what's done. But in our view, it's unreasonable to require all of those people to come back here not knowing what equipment they might have available to them, not knowing whether they're going to have access to the equipment, not knowing how much time they're going to have. we think it's far more reasonable that they be allowed to examine it in their own setting, and we do not have any intention of shipping this stuff all over the country. They're going to be there. They're going to see what we do with it. They're going to see us take splits. They're just not going to see what kind of testing we might do with those splits.
Well, here's the problem. I mean, we're here, we're in trial. I'm told that the people's opening regarding the domestic violence issues will probably conclude in a week or so, and then we will go into physical evidence. They're going to start wanting to present some of this physical evidence. How can I justify, you say it's reasonable, how can I reasonably allow you to take all this evidence to New York when we're in trial here and one of the parties wants to present it?
Well, first of all, we have no objection to them specifying which particular items they're actually going to use, and we'll do those first and get them back as quickly as possible. There are pictures of all of these things. Pictures can be used until the items come back, but I think the number of items that they actually intend to introduce physical pieces of evidence, I think, are relatively small. Much of what we've asked for are things that they feel are unimportant. They haven't even done testing on some of this stuff. So we have no objection to examining things in an order in which that we can get them back as quickly as possible so that they can be used for whatever purpose they want to use them.
All right, counsel, I'm going to want from both sides on Monday morning a list of these items as to what it is, where it is, what type of testing the prosecution wants to subject these to and why. Or I can figure out the why. And I'll take the matter under submission till I hear from the prosecution, because just these lists, Mr. Blazer, just the list of the numbers here, I would have to sit down and correlate with my own notes, and I don't know what all these items are.
Yeah, we can provide that.
All right.
So that's, you just want to know what tests we want to do.
I want to know what the item is, I want to know where it is, what its current status is, what additional testing you want to do. I'm curious about this EDTA testing, as to how you propose to do that.
I know I won't be able to tell you that Monday. I mean, we've only had 4 days for a commitment that this is what the defense would show. And so I can't tell you where the tests will be done because we're still...
No, I'm just curious as to what kind of test we're talking about here.
Oh, I'm sorry.
Because, I mean, I need to know what type of test, so I know logistically, I mean, are we going to have to, is the only place that you can do this somewhere in Virginia, or is it something we can do locally here? Is it something that one of our local universities could do?
Well, we want to try to get away from Los Angeles because of the charges Mr. Cochran's made for obvious reasons, that not that we believe them, but for obvious reasons, that we'll invite the court to even contribute if you have some labs you want to suggest. It can be there are a variety of tests that can be done in a number of places, so...
No, I'm just curious as to how we test for EDTA.
Sure.
And the samples, what type of test it is, how long does it take?
The phones are probably ringing right now.
Who does it?
Sure.
Just curious.
Okay.
Okay. All right, thank you, counsel. All right, anything else? All right, let's have the jury. All right, on the record in the Simpson matter, Mr. Simpson is again present with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, people represented by Mr. Darden and Mr. Gordon. Mr. Darden, call your next witness.
Thank you, Your Honor. The people called Denise Brown.
solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat on the witness stand. State and spell your first and last name for the record.
Denise Brown, DENISE BROWN.
Thank you.
All right, Ms. Brown, would you pull the microphone over towards you, please?
Like this?
Yeah,
Okay.
great, thank you. Mr. Darden.
Thank you, Your Honor. Good afternoon. Ms. Brown, you are Nicole Brown's oldest sister?
Yes, I am.
Do you have other sisters?
Yes, I do.
How many?
There's Dominique and Tanya. And of course, Nicole.
And you are the oldest of the sisters, is that correct?
Yes, I am.
And what is your father's first name
Lewis Brown,
and your mother's name?
Judita Brown.
And where does your family reside?
We're in Dana Point, California.
Now, if you're the oldest of the sisters, who was directly beneath you?
Nicole was.
And who was beneath her?
Dominique.
And who was the youngest?
And then Tanya.
You know the defendant seated here at the end of the council table?
Yes, I do.
Is your former brother-in-law?
Yes, he is.
When did you first meet the defendant?
Back in 1977,
And where was he when you met him?
he was playing football for Buffalo.
Did you meet him in Buffalo?
Yes, I did.
You were invited to Buffalo?
Yes.
Who invited you?
Nicole did.
Was your sister Nicole and the defendant dating back then in 1977?
Yes, they were.
And you went there to Buffalo.
She asked us to come up, Dominique and I.
So your sister Dominique also went to Buffalo?
Yes.
Was the defendant married at that time?
Yes, he was.
And who was he married to, if you know?
A lady by the name of Marguerite Simpson.
And what kinds of things did you do when you visited the defendant for the first time in Buffalo?
We went to a football game.
Did both your sisters also go to the football game?
Yes, they did.
That would be Dominique and Nicole.
And Nicole.
And was it a Buffalo Bills football game?
Yes, it was.
Did the defendant play in that game?
But he was on the sideline. I don't know if he actually played. I don't remember.
And
Certainly. With the recorder, please. All right, thank you, counsel. Mr. Darden, you may continue.
thank you, Your Honor. Both you and your two sisters watched the game that day, is that correct?
Yes, we did.
Okay, and after the game, did you go to the defendant's house?
Yes, we did.
All three of you? You and
Yeah.
both your two sisters?
Yes.
Did anything unusual happen at the football game?
Actually, no. A friend of OJ's was there. He came over and said hello to us. And Nicole said hello, kissed him on both cheeks. I said hello. She introduced me to him. And that was it.
What was that person's name?
Michael Militello.
May I just... let me ask you to speak to the microphone.
Okay.
Is that the first time you met Michael Militello?
Yes, it is. I don't know.
Millillo? Millittello? Does that sound about right?
Oh,
You returned to the defendant's home after the game, correct?
yes.
Anything unusual happened then?
Yeah, OJ got real upset, and he started screaming at Nicole.
Let me see counsel decide, please. All right, thank you, counsel. Ladies and gentlemen of the jury, you are to disregard, I am striking from the record the last question and answer. You are to disregard that, treat it as though you had never heard it. Mr. Darden.
Okay, Ms. Brown, we're not going to talk about anything that occurred between 1977 and December 31, 1984. You understand that?
Okay. Sure.
Overruled. Proceed.
Thank you, Your Honor.
Later.
Ms. Brown, your sister Nicole married the defendant in February 1985.
Yes, she did.
Okay. Did you attend the wedding?
Yes, I did. I was the maid of honor.
Do you have a half-sister named Wendy?
Yes, I do.
And where was she living in 1987 and 1988?
Wendy?
Yes.
In Arizona.
Was there an occasion during that time period in which she came from Arizona to your family's home in Laguna Beach on vacation?
Yes, she did.
And did she bring someone with her?
A girlfriend of hers who was also living there.
Okay. And what is the girlfriend's name?
Juliana Hendricks.
And did you, your sister Wendy, your sister Nicole, and Juliana Hendricks go out during that vacation period?
Yes, we did.
And was there ever an occasion when the four of you and the defendant went out and went to the Red Onion in Santa Ana?
Yes, we did.
Did anyone else go on that excursion or that trip that night?
There was Dino Bucola and Reggie McKenzie.
And who was Dino Bucola?
He was my boyfriend at the time.
And who was Reggie McKenzie?
A friend of OJ's.
And he is a former
Football player.
And was there some plan or agreement amongst the group to meet at a certain location and at a certain time?
We were going to go and meet OJ, and we were running a little late, and we got there, and he got upset, but that blew over, and then we continued on.
Okay.
Went to the club.
So when you arrived late, the defendant got a little upset, you say?
Yeah.
Okay.
He was annoyed with us, for being late.
Okay, now it was you, Nicole,
Wendy,
and Julianne?
Right.
Okay. And then the group went out, is that correct?
Right.
Did you all go out in one car?
Oh, there were a couple of cars.
Okay. And who owned the two cars that you used to go out in that night?
I think that night it was OJ's car, and I'm not sure who else was driving, or who else's car it was.
Okay. Did you go to the Red Onion?
Yes, we did.
Is there a bar in the Red Onion?
Yes.
Okay. And did you have something to drink?
Yes, I did.
Really? What did you drink?
That we were all, well, actually, we were all doing shots of tequila.
The defendant was doing shots of tequila?
Yes.
Was Nicole doing shots of tequila?
Yes.
Did Julianne drink tequila?
I think she may have. I'm not sure, but I know that we were.
How about Reggie McKenzie? Did he drink shots of tequila?
Yeah, he did too.
Okay. Now, were there other persons or patrons in the bar?
Oh, it was packed. There was lots of people there.
And did some of those patrons recognize the defendant?
Yeah, he always gets recognized wherever he goes.
And did the people walk up to the defendant and talk to him?
Oh, sure.
Did he sign autographs?
I don't know if he signed autographs that night, but he's friendly to people. He shakes hands.
Did people in the bar buy him anything?
Oh, they could have. I think the bartenders, they had given him shots of tequila and things like that, sure. I mean, that happens when he goes out.
So the drinks were free?
I'm not saying all of them were, I'm not sure, but people do tend to buy him drinks, and they were buying us drinks too, because we were with him.
And did you see the defendant drink shots of tequila?
Mm-hmm. Yes.
Okay. Did anything unusual happen that night in the Red Onion?
Yes.
What was that?
Well, we were all drinking and goofing around and being loud and dancing and having a great time. And then at one point, O.J. grabbed Nicole's crotch and said, "This is where babies come from, and this belongs to me." And Nicole just sort of wrote it off like it was nothing, like she was used to that kind of treatment. And it was like, I thought it was really humiliating, if you ask me.
And when he grabbed your sister's crotch and said, "This is where babies come from," is that what he said?
This is where babies come from, and this belongs to me, and this is mine.
And when he said this, and when he grabbed her in the crotch, were there people around?
Oh yeah, the bar was packed.
Strangers?
Yeah. Yeah. He was talking to the strangers.
Did your sister Nicole react to this at all?
She just kind of wrote it off and just, shrugged her shoulders. Stop it or whatever. I mean, it was, I don't know. She didn't really react. Thanks.
Did the defendant appear mad or angry or upset when he grabbed your sister's crotch and made these statements in front of these strangers?
No. He wasn't angry. It was his. That's the way just the way he acted, the way it was like, this belongs to me, this is mine. He wasn't angry when he said it, he just made it a point. He wanted it to be known, but that was his.
Was she wearing a dress or was she wearing pants, if you recall?
Oh, I don't remember.
And during the time that these strangers were approaching him and shaking hands and things like that, did he appear to shy away from the attention at all?
Oh, no. No, not at all. He loves the attention. He loves it. He's got a big ego. It feeds his ego.
Yes, please. All right, thank you, counsel. Ladies and gentlemen, I'm going to instruct you to disregard the last answer regarding the defendant's ego. That question and answer is not relevant to the issue before the court at this time. And Ms. Brown, if I can ask you, would you please listen carefully to the question that the attorneys asked of you, and if you would answer just the precise question that they asked you, this will go a lot easier.
Okay.
All right, thank you.
Sure.
Mr. Darden.
Thank you, Your Honor. You okay, Ms. Brown?
Yeah.
Let me direct your attention to the La Cantina restaurant. Okay?
Okay.
Are you acquainted with someone by the name of Ed McCabe?
Yes, I was.
This is someone you've known over the last decade or so?
I've known Ed for a while. I used to date him.
And when did you stop dating Ed McCabe?
Oh, I think we may have gone out for a year or two, maybe 2 years.
You still speak to Ed McCabe?
Not too often.
Okay. And in what city and state does he live?
He's in New York.
You recall an occasion when you and Ed McCabe and Nicole and the defendant went out to dinner?
Yes, I do.
Okay. And, and where did the four of you go after you left the La Cantina restaurant?
We went to OJ's house. OJ and Nicole's house.
On Rockingham?
Yes.
Now, had you had something to drink at the restaurant before?
Yeah, margaritas.
And did the defendant have something to drink?
Yeah, we all did.
All four of you?
Yes.
Okay, and what did you do when you returned to the defendant's home on Rockingham?
We were sitting at the bar talking, having some more drinks, and talking.
Okay, and while you were talking, did you say something to the defendant?
Yes, I did.
What did you say to him?
I told him he took Nicole for granted, and he blew up. He got...
Right. Ms. Brown, if you would, don't volunteer anything beyond the actual question, please.
Okay.
All right, thank you. Mr. Darden.
You told the defendant that he took Nicole for granted?
Yes,
Why did you tell him that?
because she did everything.
Sustain.
On 352 grounds, Your Honor?
It's irrelevant. Why this witness thinks that Ms. Brown Simpson was taken for granted is not relevant. What's relevant is the fact she made the comment and any reaction to that comment.
What reaction, if any, was there by the defendant when you told him that he took your sister Nicole for granted?
He got extremely upset.
And what
He-
happened next?
He started yelling at me. I don't take her for granted. I do everything for her. I give her everything. And he continued. And then a whole fight broke out. And pictures started flying off the walls. Clothes started flying. He ran upstairs, got clothes, started flying down the stairs. And grabbed Nicole, told her to get out of his house, wanted us all out of his house. Picked her up, threw her against a wall. Picked her up, threw her out of the house. She ended up on her... She ended up falling. She ended up on her elbows and on her butt. Then he threw Ed McCabe out. We were all sitting there screaming and crying. And then he grabbed me and threw me out of the house.
Are you okay, Miss Brown?
Yeah, it's just so hard. That'll be fine.
Your Honor, if it pleases the court, can we adjourn and continue this Monday morning? Your Honor, the court instructed Bailiff to assist Ms. Brown if she needs assistance.
No. All right. Ladies and gentlemen, we're going to take our recess for the afternoon. Ms. Brown, if you just stay there for just a second. We're going to take our recess for the afternoon. Please remember my admonition to you. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to speak to you about the case or speak to anybody else about it. Do not conduct any deliberations till the matter has been submitted to you. I'll see you back here Monday morning, 9 o'clock. Have a nice weekend. Thank you, counsel. Anything else we need to put on the record? All right, we'll stand in recess Monday, 9 a.m.